Tripp here from the Watson firm, giving you all an update on the Defend Trade Secrets Act. If you're not familiar with this, this is the single biggest change in federal trade secrets act that we've ever seen. So the big thing to keep in mind is this law was passed back in May of this year. It became effective immediately after overwhelming support in both houses of Congress. So when it was passed, it became effective, and the big thing about this new law is that it's the first time that we're ever seeing federal protections and federal causes of actions in civil cases for people that have misappropriated trade secrets. Now, I'll tell you a little bit why. Give you a little bit of a background if you're not familiar with trade secrets law, but trade secrets are typically covered on the state level. Most states have adopted a code called the Uniform Trade Secrets Act. And basically 47 states just basically rubber stamped this act and put it in place with some minor changes. The only states that haven't are New York and Massachusetts, and then North Carolina put in an alteration of that code. But that's typically how it is in most states. Specifically, Alabama has adopted the Uniform Trade Secrets Act pretty much verbatim. And the big thing about the UTSA is that it provides not only a definition for what trade secrets are that's much broader than what a lot of us think about, but it actually gives us multiple remedies such as injunctive relief, actual damages, and even attorney's fees, and in some situations punitive damages if the violation is willful or malicious. Now, that was really great to have on the state level, but if you had potential interstate misappropriation of trade secrets, you didn't have a whole lot of options until now. Now, with the Defend Trade Secrets Act of 2016, there is a federal civil cause of action for filing suit on misappropriation of trade secrets. This now gives you the option of filing suit in federal court for the first time based upon a federal question of law. Now, practically speaking, the federal law has adopted most of what the Uniform Trade Secrets Act had in there in the first place. So we're not seeing a huge change except for some stylistic changes and some other stylistic changes that we're seeing in the actual code itself, with the exception of some big changes that we've seen on the periphery. The first big change that we've seen is the seizure option. The federal code now allows for ex parte verified complaint to be filed, and that basically just means that you're swearing that everything in the complaint is true, but it does not require them to answer the complaint, and immediately you can actually seek to have federal enforcement and federal marshals seize the trade secrets that might be disseminated or might be destroyed prior to that dissemination or destruction. So, huge change from the existing code. The next is royalties. Royalties have long been understood to be a potential remedy in certain states for trade secrets violation. This is now explicitly provided in the federal code. So this gives us an opportunity to go after somebody and say, if you've been using that, or if you continue to use it, then we're entitled to some type of royalty, but that's only in the actual definition is exceptional circumstances. The next big one is whistleblower protections. Basically, if an individual discloses a trade secret to law enforcement for the purposes of reporting a crime, then there can't be a violation of the code. There cannot be any type of damages or any kind of punishment on that employee if that happens to be an employee either. So this typically just falls in line with the rest of the whistleblower provisions that we've seen in the federal code. So this is not a huge surprise that this is in there, but that is in there. So if you do have something that pops up that triggers on that, be aware of that. The next is international reporting. So it's very difficult for us to determine whether or not trade secrets violations are happening because the data that we have is just not very reliable. This actually, the new code actually provides for the United States Patent and Trademark Office, along with some other federal agencies, to start collecting data and issuing reports on this. So it doesn't give us a whole lot of enforcement provisions that weren't already there. Theoretically, it's just more reporting that we can actually see on the back end. And lastly, an interesting little peculiar note on this is that it doesn't actually preempt state laws. So a lot of times when Congress enacts a law, they preempt state law. So if the state had a law on that and the federal law exists as well, the federal eats the state law up. Not so in this case. And this is pretty interesting because we can end up having potentially two separate causes of action and two separate case laws, and we can end up choosing whether we want to file in state court or in federal court, depending on which one works best for us. So that's a real big change. The bottom line is here that the Defense of Trade Secrets Act is the very first civil foray in federal courts into trade secrets. So this is a big change that we're seeing in trade secret law. The very first thing that you probably need to do if you're a company that uses a lot of trade secrets or confidential information, it's probably good to go ahead and update those non-disclosure agreements. If you pulled something off the internet, chances are it probably hasn't been updated since the 80s, and that probably does not even reflect many of the states passing the Uniform Trade Secrets Act. So you'll probably want to update your non-disclosure and confidentiality agreements to reflect the changes on the new law anyway, because they're probably outdated. But like I said, with the change in the Defense of Trade Secret or Defend Trade Secrets Act, you'll probably want to update your non-disclosure agreements anyway, because practically speaking, there's probably some provisions in there that have immediately become outdated. Next is to perform a confidentiality audit. I always recommend performing a confidentiality audit if you do a lot of work with trade secrets or confidential information, because there could be something that is very important for you to protect, but if you're not taking the right steps to protect it, you might be wasting your time. So some things might be easily protected simply by putting a password on them, but that's not going to be enough for really high-level trade secrets. So you'll probably want to sit down with an attorney and speak about what specific trade secrets you're trying to protect and what methods you need to protect those. Like I said, some can be simply password protected. Many others are going to need to be encrypted, have limited access, maybe even set up on a specific piece of real estate completely dedicated to that with just controlled access. It's just really going to depend on the type of trade secret that you're working with. The third thing to think about is you might want to reassess those lawsuits that you were thinking about. Now that there is a federal cause of action with a 3-year statute of limitations, if you were considering that maybe state court might not be the best place for you to file suit, you now have the option to file suit in federal court. So with that change, you now potentially have a different option to pursue that misappropriation of trade secrets. It might be time to rethink of that lawsuit. The last thing is, and this is a general thing, but with any type of trade secrets violation, litigation happens fast. There's typically very early TRO and preliminary injunction hearings, so a lot happens in a very short period of time. However, with the seizure provisions on the federal level, which basically allows one company to go into another company and raid their servers or any type of information that they may have, that can happen very, very quickly. So it's important to make sure that if you get any type of tip that there might be some trade secret misappropriation or potential trade secret misappropriation, act fast, talk to an attorney, but make sure that you have a policy in place that can protect you if something goes south. So if you do have any questions about trade secrets, how to enforce them, or how to protect them, give us a call. My name is Tripp at the Watson Firm, and we look forward to hearing from you. And if you do have any other questions, feel free to let us know. We're glad to help you out. Have a good one.